Hello friends, in the series on the income tax cases, today we will discuss an issue which is based on the prosecution under the Black Money Act for non-disclosure of some foreign bank accounts. In the present case, the prosecution was initiated against the assessee for the assessment year 7-8 and assessment year 9-10, although the provisions of Black Money Act were not applicable for those years because the Black Money Act came into existence on 1st July 2015. So, what should be the course of action for the assessee in these types of matters? This has been well taken by Karnataka High Court in the case of Srimati Dhanashree Ravindra Pandit versus Income Tax Department. This issue has been reported in 466 ITR at page number 1 and the date of the judgment is 7th June 2024. In the present case, the assessee and her family members opened a company and closed that company in near about the year 2008, 2009 and 2010. When the company was incorporated, bank account was also opened in the Singapore and some $16,000 and $40,000 were deposited into that bank account. For those assessment years, it was not the law at that time to disclose those bank accounts, but the department registered a complaint against the assessee that the assessee has violated the provisions of section 72 and the revenue filed a complaint for the violation and under the section 200 of the Criminal Procedure Code 1973 for an offence under section 50 and 52 of the Black Money Act. It was the allegation of the revenue that the assessee has not disclosed the bank accounts. The complaint was filed and it was pending near Additional Judicial Magistrate. The assessee also filed the writ petition for that complaint, and when this matter was heard by Karnataka High Court, the Karnataka High Court said that the Black Money Act is a special enactment and the Constitution of India is not an statute, but the Constitution of India is the fountainhead of all the statutes. Meaning thereby that if the Constitution does not allow something, then that cannot be achieved even by creating a special statute. The High Court talked about Article 20 of the Constitution of India, which comes under Chapter 3rd of the Constitution of India, which says that a person will be convicted for an offence which is an offence only as per law, which is in force at that particular time. Since in the present case, the Black Money Act came into existence on 1st July 2015 and the transactions were related to a period which was near about 5-6 years back in 2007, 8, 8, 9. So, the Karnataka High Court said that in the present case, the prosecution initiated did not and could not pass the constitutional muster under Article 20 of the Constitution of India. So, the Karnataka High Court in the present case quashed the proceedings which were pending before the Additional Judicial Magistrate. Friends, this case is very important because the serious proceedings like criminal proceedings or prosecution proceedings have a very great impact on the assessee, and those proceedings should be initiated only in the rarest of the rare cases and after ensuring that whether that prosecution proceedings are liable to be initiated or not. So, if the prosecution proceedings will be initiated for a period which even does not relate to the offence of the assessee and which even relate to the period which is well 4-5 years back from the date on which the Black Money Act came into existence, then it will create a situation of havoc-like situation in the fiscal laws, and the people will lose faith in the fiscal laws. In the present case, the court quashed the prosecution proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Shrimati Dhanashree Ravindra Pandit versus Income Tax Department, and this case has been reported in 466 ITR at page number 1. The matter has been decided on 7th June 2024. Thank you, friends.